What is the supreme law of the Federation? Under Article 4 Clause 1 of the Federal Constitution, it is expressed that, this Constitution is the supreme law of the Federation, and any law passed after Merdeka Day which is inconsistent with this Constitution shall, to the extent of the inconsistency, be void. What is the definition of Constitution here? According to Act 388, which is Interpretation Acts 1948 and 1967, Constitution means the federal constitution and includes the constitutions of the states. Meanwhile, federal constitution means the Constitution of Malaysia and does not include the constitution of the states. If Article 4 Clause 1 had intended to limit to questions relating to the federal constitution only, then it would have used the term federal constitution instead of constitution, or it would have made its intention clear by expressly excluding the state constitutions from its ambit. Such clear intention of Article 4 Clause 1 can be found in the Interpretation Acts 1948 and 1967, which expressly excludes the constitution of the states from the definition of federal constitution. Therefore, the supreme law of the Federation is the federal constitution and includes the constitutions of the states. Why do we need to understand the definition of constitution? We need to understand the definition of constitution, which means federal constitution and includes the constitutions of the states, because it is important for us to see if an act of parliament, amendment and the action of the federal government is consistent or not with the rights of the people in Sabah and Sarawak as embodied in the state constitution. Now, based on the definition given in Act 388, we understand that both the federal constitution and state constitution is supreme law in the Federation of Malaysia. With the understanding of the definition of the constitution, and the need to observe the consistency between the federal constitution and state constitution, now we will expose the unconstitutionality due to inconsistencies in various federal law and amendment of the federal constitution which become the 13 May 1969 tragedy of Borneo. The Borneo states of Sabah and Sarawak have been living in hell since this tragedy happens in 1969. But, what actually happens in the Borneo states of Sabah and Sarawak during this darkest hour of Malaysia? To unravel what happened to the Borneo states of Sabah and Sarawak, we need to look at the law that is already in place in Sabah and Sarawak. The Borneo states of Sabah and Sarawak already has their own law in owning and governing their own continental shelf under Sarawak, Alteration of Boundaries, Order in Council, 1954 and North Borneo, Alteration of Boundaries, Order in Council 1954. In the Borneo states of Sabah and Sarawak, the territory of the state means all area within the boundaries of the states which comprised the territory of Sarawak immediately before Malaysia Day, and includes, by virtue of the Sarawak, Alteration of Boundaries, Order in Council, 1954 Volume 6. Page 1025, the continental shelf being the seabed and its subsoil which lies beneath the high seas contiguous to the territorial waters of Sarawak. This law was enforceable in Sabah and Sarawak before the formation of Malaysia and remain enforceable after the formation of Malaysia. In Sarawak, even before the formation of Malaysia, Oil Mining Ordinance 1958 has been enacted to govern the exploration and mining of oil and gas throughout the state. Oil Mining Ordinance 1958 is an ordinance to make better provision in the law relating to oil mining in Sarawak and on its continental shelf. In this Oil Mining Ordinance 1958, it has been properly defined that continental shelf means that area of the continental shelf which has been included in the boundaries of Sarawak by virtue of the Sarawak, Alteration of Boundaries, Order in Council, 1954. In this Oil Mining Ordinance 1958, alienated land has been defined, which means land the oil rights in which are vested in the Crown but the surface of which has been alienated at any time whether such surface has been revaised in the Crown or not. Again, It is also has been defined that land and lands include the foreshores and submarine areas beneath Sarawak waters and also the area of the continental shelf. This is consistent with Article 47 Clause 2 of the Constitution of the State of Sarawak, which expressed that any land in the states which immediately before the commencement of this Constitution was vested in Her Majesty shall on the commencement of this Constitution vest in the state. This means, the continental shelf of Sarawak has been vested to the state of Sarawak.